Hello and welcome to the Blackstone Solicitors channel. Today we're exploring a concept that sits at the more dramatic end of company law: the just and equitable winding up of a company. Now, that might sound like something out of a courtroom drama, but in reality, it's a vital legal remedy for shareholders when a company can no longer fairly or properly continue in business. It's a mechanism designed to bring things to an orderly close when all other options have failed. Let's start with what it actually means. Winding up is the formal process of ending a company's life, selling off its assets, paying off its debts, and then dissolving it. Normally, winding up happens because a company is insolvent or has reached the end of its purpose. But sometimes, a company can still be solvent, perfectly capable of trading, yet the relationships within it have broken down so badly that continuing is no longer possible. That's where a just and equitable winding up comes into play. In simple terms, a shareholder can ask the court to wind up a company on the ground that it's just and equitable to do so. It's an appeal to fairness and reason, a recognition that even though the company might be financially healthy, the situation has become untenable. So when might that happen? Often these cases arise in small private companies where the shareholders are also directors, perhaps family businesses or partnerships that have incorporated. The law sometimes refers to these as quasi-partnerships because they operate much like personal partnerships built on mutual trust and confidence. When that trust breaks down, say because of a dispute, exclusion from management or misconduct, it may be impossible for the business to continue. The shareholders may no longer be able to work together, and there may be no practical way for one to leave or sell their shares. In those circumstances, the court can step in and say, essentially, this company can't go on, it's fair and reasonable to bring it to an end. Imagine two friends who set up a company together. They each own half, and they both run the business day to day. Over time, one begins to take decisions without consulting the other, perhaps even diverting opportunities for personal gain. Trust disappears. Communication breaks down. There's no market for their shares, and no agreement in place for one to buy the other out. The result? Deadlock. The company can't function, and neither can walk away. In that situation, a petition for just and equitable winding up may be the only fair way forward. However, courts don't grant these orders lightly. Winding up a company is a serious step. It ends the business entirely. The court will always consider whether other remedies, such as an unfair prejudice petition or a share buyout, might be more appropriate. The petitioner must show that there is no viable alternative and that it would genuinely be just and equitable to wind up the company. It's about fairness, not punishment. If the court agrees, a liquidator is appointed to sell the company's assets, pay creditors, and distribute any remaining funds to the shareholders. The company is then struck off the register and ceases to exist. At Blackstone Solicitors, we often act for shareholders, directors, and companies involved in disputes of this nature. These situations are usually highly personal and emotionally charged, especially in small, owner-managed businesses. Our role is to help clients understand their rights, assess the best course of action, and, where possible, resolve matters without the need for winding up. But when winding up truly is the only fair solution, we guide our clients through the process with clarity and confidence. So, to sum up, a just and equitable winding up is a last resort remedy for shareholders when a company's internal relationships or structure have broken down so completely that carrying on is no longer fair or possible. It's a way of drawing a line under a situation that has become unworkable, allowing everyone involved to move on. At Blackstone Solicitors, we're specialists in shareholder and corporate disputes. Whether you're considering a just and equitable winding up or looking for ways to avoid one, we can help you understand your options and protect your interests. If you found this video useful, give it a like and subscribe to our channel for more clear, practical insights into company and commercial law. And if you need advice about your own situation, get in touch. We'd be delighted to assist. Thanks for watching, and we'll see you in the next video.